Okay, welcome back to part 3 here of midterm review, and we don't have too much left to go over in our civil rights and liberties unit here, but let's continue on. And in terms of freedom of expression and press, and one of the foundational documents that you will need to know is Tinker v. Des Moines, and this is going to create a Tinker test named after the litigants. And the basis of this is, does it cause a disruption to the educational environment? In this case, you had two siblings wearing a peace sign to protest the Vietnam War. And in this case, it's going to establish a standard set by the Supreme Court. And they rule actually in favor of the students, that simply wearing an armband is protected free speech because it's really not creating a disruption. However, if you were to come into that school building with an alcoholic shirt or something more shocking with the F word, for example, that would not pass the Tinker test. And as a result, educational officials could censor that because, again, at the end of the day, schools are made for educational purposes and not really so much for political speech that is disruptive. Okay, continuing on with Schenck v. U.S., this dates back to World War I, and this was a law that was forbidding, or the Supreme Court case was over a law forbidding the distribution of leaflets urging men to resist the draft during World War I. And this was upheld as being constitutional, despite the fact that it's sort of infringing on people's First Amendment rights. And the thought process here is that this is creating the clear and present danger test here. So, for example, not all speech is absolute. You actually have restrictions. For example, if you were in a crowded movie theater and you yelled fire, you are having people rush the exits in a very dark, crowded area, and people could get trampled, people could get stepped on, and as a result, you are creating a danger. So that would not pass the clear and present danger test here. And consequently, your speech is not unlimited, as was recognized in Schenck v. U.S. And then in 1971, we have the case of New York Times versus the United States. And this is, of course, dealing with the Pentagon Papers case, in which the government cannot prevent something true, again, true, from being published, even if it was obtained illegally and conveys government secrets. So this is a big First Amendment win, particularly for news publications such as the New York Times, to be able to publish things, especially, again, even if it is obtained illegally and conveys government secrets that could even be damaging to the United States government. So this is a huge boon for the freedom of press part of the First Amendment. And keep in mind that all of these cases are on my YouTube channel for further explanations. Now, in terms of criminal cases, Miranda v. Arizona, this is going to establish that the police have to inform you of your rights to remain silent and your right to counsel, or in a sense, have a lawyer present when being questioned here. And this dates back to a case, Ernesto Miranda is being arrested, and at this point, police had never had to read anybody their rights for this particular type of arrest, and consequently, Miranda is going to take this all the way up to the Supreme Court. And ultimately, it's going to set a precedent for the police in instructing that they have to inform suspects of their rights when they are being arrested, as well as with respect to remaining silent and their right to counsel. And then we have Gideon v. Wainwright, where the guarantee of a right to a lawyer in criminal cases is going to be established. This is a huge boon for public defenders that had not really existed prior to this point, or really only in capital or significant cases. But even if you get arrested for even very minor things, like for misdemeanors, like stealing a candy bar, you would be entitled to a public defender should you not be able to offend one. Keep it in mind that this is not pertain to if you're being sued by someone for financial matters. This is only for criminal cases. And then we have a Fourth Amendment case dealing with Mapp v. Ohio that is going to establish something called the exclusionary rule, that evidence that is illegally seized by the police cannot be used against you. So, for example, if the police were going to raid your house, they don't have a warrant, and they obtain illegal materials in your household, those could not be used against you, hence they have to be excluded, hence the exclusionary rule here. And perhaps the most important amendment in Unit 3 is the 14th Amendment. This is going to establish a few important clauses, in particular the Due Process Clause, that states may not deny persons life, liberty, or property without due process of law. So this is going to be very important with respect to civil liberties cases. And then we also have the Equal Protection Clause, which is going to state that states may not deny any person within its jurisdiction the equal protection of laws. And this is going to pertain more to civil rights cases, more towards specific groups, as opposed to civil liberties, meaning all people involved. So for example, we're going to see the Equal Protection Clause being used to protect minority groups in many cases here. Now, one interesting case here is actually a Second Amendment case, but also the 14th Amendment is going to get dragged into it in McDonald versus Chicago, which is going to strike down the handgun ban on the 14th Amendment as it is considered a fundamental right. And what's important here is it's going to use selective incorporation. Essentially, with selective incorporation, it's going to make the Bill of Rights pertain to all 50 states, but it has to be done amendment by amendment by amendment. And it's going to incorporate the Second Amendment in terms of this portion here of McDonald v. Chicago to pertain to all 50 states. And the selective incorporation comes from the 14th Amendment. And then we also have Roe v. Wade, one of the more controversial decisions deliberated in coming down in a 7-2 decision in 1973 in favor of Roe. And basically, this is going to be based on the Due Process Clause of the 14th Amendment with respect to liberty, and it's going to be considered a fundamental right to privacy. Interestingly enough, the Due Process Clause is going to use the word person, but keep in mind that the Supreme Court is going to determine that this does not include the unborn. Interestingly enough, in this case, the Supreme Court is going to reference the Ninth Amendment, one that is not really referenced all that much, but it's going to say that the reservation of rights to the people includes a woman's decision. The Ninth Amendment basically states that all rights not, enumerated or listed don't necessarily mean that those rights are denied to you. So, for example, brushing your teeth is not something in our Constitution. You, by brushing your teeth, that is actually a Ninth Amendment right, believe it or not. So they are going to use the Ninth Amendment to make their decision here. And then with respect to civil rights, some very important legislation here. Civil Rights Act of 1964. This is going to make racial discrimination in hotels, restaurants, and public accommodations and locations illegal. We're also going to see the Voting Rights Act of 1965, basically saying the government cannot deny individuals the right to vote. We have literacy tests that we're trying to prevent, in particular, people who were illiterate, and this was disproportionately directed toward black people. And then the 24th Amendment is going to be passed, and that's going to outlaw poll taxes officially. And the foundational document that really encapsulates civil rights is going to be the letter from a Birmingham jail written by the great Dr. Martin Luther King Jr. that basically is going to lay out a framework for nonviolent resistance, and that's going to be civil disobedience, that people have almost a moral obligation to disregard an unjust and an immoral law, that people really don't have to just simply ignore it, that they have a moral obligation to break unjust laws. I do also have a video on that should you want more in-depth information here. And then another important case is going to be Brown v. Board of Education. And this is going to overturn a precedent. And keep in mind that the Supreme Court does not like to overturn precedents. They adhere to stare decisis. And in this case, they are going to overturn Plessy v. Ferguson's separate but equal doctrine. And it's going to utilize the Equal Protection Clause of the 14th Amendment. The NAACP, a very prominent African-American interest group, along with Thurgood Marshall, are going to argue under Chief Justice Earl Warren's court, and it's going to officially end segregation in public schools. A very, very important case for sure. To end here, other important aspects of the 14th Amendment include women. For example, Title IX with respect to equal funding at the collegiate level for sports. We also have a very prominent interest group known as NOW, the National Organization of Women, very instrumental in the women's rights movement, and even for the Equal Rights Amendment. And then with the LGBTQ plus population here, same-sex marriage and Obergefell v. Hodges being ruled in 2014, and even having Don't Ask, Don't Tell repealed, which was under President Clinton and then later repealed, and also having same-sex rights begin to be advanced a little bit further in 2003 in a case known as Lawrence v. Texas. This is not required as a foundational document, but I do mention it because it's going to be one of the first Supreme Court victories for the LGBTQ community before we get to Obergefell v. Hodges, which will officially legalize same-sex marriage in all 50 states. So that was a brief overview. I highly encourage you to go through the areas which you need a little bit more background in, that you're a little bit unfamiliar with, and there are plenty of videos on my YouTube channel should you wish to consult those. Thank you so much for listening.